Now let's listen to the approach that Keith Davidson would take to fight for your inheritance.
Hi, this is Keith Davidson at Albertson and Davidson. So we have a problem here with Simon and Todd because they've found out that there's a substantial amount of the business that they've been working with their father that they probably are not going to receive, or that somehow is going to pass to their stepmother, Patty. And the problem really comes about because Walter didn't do any planning. And so it's an intestate estate, and under our California intestate laws, Patty's entitled to 100% of anything that's community property, and at least a third of anything that's separate property, because there's 2 children that Walter had. So that means that at a minimum, Patty's probably going to get anywhere from a third to 100% of this business. And that really puts Simon and Todd in a bad position. Of the options that we presented, certainly the first thing I would do is ask Simon and Todd to see if they could find any type of holographic will. So they know that their dad died without a formal will, so there wasn't a will that you normally would see that's typed up by a lawyer and signed and witnessed and all that. But there's a lot of different types of handwritings that people can do during their lifetime, and some of these handwritings can be considered a will. And we refer to that as a holographic will. And a holographic will is anything that's in the testator's own handwriting that they sign. And so if Dad had sent them a note, for example, that says, when I die, I want you two to have my business, and he signed that note, that could suffice to be a holographic will. And that would be a big difference here, because at least then Simon and Todd would have some rights to that business. Now, a lot of this is going to come down to, is the business community property or separate property? Because if it's community property, even if they do find a holographic will, only half of that community property can be given away from the spouse. The other half has to go to Patty. If it's separate property, then Walter could give 100% of it to the kids and exclude Patty. So there's always going to be that argument that's going to have to be worked out. We don't have enough facts here to really get to the bottom of that argument, but that's going to be a big part of this case as to how the assets go. If they can't find a holographic will, and chances are they can't, then they have a lot of choices here that they need to make. Obviously, negotiating with Patty would be a great way to start to see if Patty's open to a discussion as to the ownership of the business. It could be that maybe Patty doesn't want to run the business, or she doesn't know how to run the business, or she wants some money in exchange for the business. If that's the case, then Simon and Todd might be able to negotiate with her. Simon and Todd do need to be a little realistic here, because they are going to lose something to Patty. So they're going to have to come up with something to buy Patty out if they're going to successfully negotiate. If that doesn't work, then they either can bring a contract to make a will and say that their father had a contract with them, or they can file what we call a creditor's claim. Either way, there's a potential that they might be triggering a no contest clause if Walter has a trust in place for other assets. Now, if Walter just has no trust or will whatsoever, then they don't have to worry about a no contest clause. But if there's a trust over the home, for example, and Simon and Todd were going to get something from that, then filing a claim with the probate court could put that gift in jeopardy. But let's assume that that's not happening here. They just want to secure the business. That's the only thing that they want. It's the only thing that they're going to get. Then they have 2 approaches. With the contract to make a will, that's a claim where you say that you gave up something in exchange for the receipt of gifts at death. So here, Simon and Todd would have to say that they gave up pay, they gave up benefits, they gave up pursuing other opportunities in exchange for getting the business. But they would have to prove that by clear and convincing evidence, because they don't have anything in writing. And if you don't have anything in writing, you have to prove by clear and convincing evidence that there was an actual agreement, a meeting of the minds between Dad and Simon and Todd. If Simon and Todd chose to just give up other opportunities to help Dad out because they wanted to be nice to Dad and help him, that wouldn't be enough to base a contract to make a will. You have to have an actual contract or an actual agreement between the parties for that to work. And finally, Simon and Todd could file a creditor's claim. The creditor's claim would have to be based on something. So perhaps they could say that they bought into the business, or they earned some of the business with sweat equity, or they can say that Dad said that they were joint owners of the business, and all they want is to at least get their joint ownership out and they're each entitled to a third under joint ownership. The problem with that, of course, is they don't have anything in writing to establish their joint ownership. So they're going to have to somehow prove up that they were joint owners of this business. It's a very, very tricky situation that Simon and Todd find themselves in, but it's not uncommon. A lot of times families don't document these sorts of things. So to recap our options, number one, definitely look around, see if there's any evidence of a holographic will, any writing at all that Dad signed that would give Simon and Todd some right to the business. Number two, see if you can negotiate with Patty. And the third and fourth option is file a contract to make a will claim or a creditor's claim and see if you can get something using either one of those avenues.